Still waiting.
I've got the 3, 2, 1 then, mate.
Hello all. Welcome to the restarted Friday webinar series after a brief break last week for both Frank and I. I am Chris Irons, Strata Advisor, former Commissioner for Body Corporate and Community Management in Queensland. With me, Frank Higginson. Frank, welcome.
Thank you, Chris. Thank you, everyone. I suppose last week we went to opposite ends of the country. Chris was down in the Barossa and I was up in North Queensland. And the Hawaiian shirt is a little, I suppose, my way of saying goodbye to Dean Jones, because this has been 2 test matches which he played in. So it's the cricket shirt. It gets worn a couple of times a year, but it is indestructible. So the Lowe's Hawaiians, very much worthwhile investing in.
That's a really nice little tribute, Frank. Thank you. Welcome back, everybody who's tuning in today. Don't forget, as always, you can ask us questions live throughout. Just post a question on the Facebook page and we'll get to as many of those as we can during the session. Please don't forget to like and share as well. The more the merrier. Gets us the topics, the interest, the discussion happening. That's in everybody's benefit, I would suggest. This week, Frank and I thought we'd tackle the pretty thorny and delicate topic of discrimination in strata. It's a topic that gets bandied around quite a bit, and it was particularly prompted this week by a story that we came across in South Africa. I might actually put up the link to it so everyone, you can read this at your leisure. But basically what happened is that there was a claim of religious discrimination in the South African equivalent of strata from some residents, and I've just put up the link there to the story, from residents who claimed that they had been told that their lighting of incense, so this was Hindu residents, their lighting of incense was causing a nuisance, and then received a letter from the Body Corporate Committee equivalent to state that their religious practices were a nuisance. Now, quite apart from the committee, perhaps should have taken a bit more care in how they addressed that particular issue. That's a pretty delicate set of circumstances on a number of levels. But I think Frank and I, we spoke about that and we thought that's a good topic to have a little bit of a chat about, isn't it?
It comes up regularly, and in a range of contexts, and not all of them are actual discrimination. I think it's sort of, I suppose we'll get into the detail of what people call discrimination and what that actually might be, because they can be 2 different things. And interestingly enough, when you do a word search of the 188,000 words that are lurking around in the Body Corporate and Community Management Act and related modules, discriminate is used once. And that is in relation to bylaws, not discriminating between owners and occupiers. So, and I suppose for those of you that are frequent attendees at these seminars, Section 180 of the BCCM Act we talk about quite a lot. That's the gospel for what bylaws really can't include. And our state legislature's made it pretty clear that there can't be one set of rules for tenants and one set of rules for owners. So owners can use the pool up till 9 p.m, but tenants can't use it after 6 type stuff is black and white unlawful. So that's the discrimination that is referred to in the Act, but that's not really the sort of discrimination we're talking about today, Chris, I think, is it? Really?
No. And I think a good way of thinking of that one, Frank, is that discrimination you're talking about is the use of the term in its most literal sense. Discrimination there is effectively making a distinction between 2 things or 2 or more things. Discrimination that people tend to talk about, and I suppose where we're going today, is discrimination based upon some criteria which has been deemed unlawful by legislature in Australia. So it's really important to make that distinction. And when I was Commissioner, I used to hear from clients, parties all the time claiming that they were being discriminated against. And there might have actually been a couple of instances where that was true. But what somebody meant by being discriminated against was something quite different, and we'll get to what that is in a moment. So let's talk a little bit about, we've spoken a bit about legislation, let's expand upon that. So body corporate legislation is about decision-making processes in bodies corporate. So that's body corporate legislation. Then there is separate legislation that deals with discrimination and then there's separate legislation which deals with human rights. So body corporate legislation does not concern itself with human rights practices, only concerns itself with discrimination on that very specific singular topic. Queensland now has a piece of human rights legislation, has had so for about 12 and a half months, I think. Oh, sorry, a year and a half, I should say. One of the big questions which comes up is, does a body corporate have to comply with that legislation? It's an interesting one, that one, isn't it, Frank?
It is, and I suppose where I've got to over my time now, I get narrower and narrower in what we do. So pieces go back and all the bits and pieces, absolutely. And I do remember when the publicity about the human rights legislation appeared, I thought, okay, I'll actually go and read a new piece of legislation. And my take was, when I looked at it, that it really only applies to government sort of organisations as opposed to private ones.
That's right.
Yeah. How are they defined in there?
Public entities, I think, is the term used. So a body corporate of itself is not bound by human rights. But here's a little question for you to have a think about, everyone who's watching. There are some instances where a body corporate acts upon instruction from my former office in relation to a few things. Could it be said that in those circumstances they are performing the role of a public entity? I'll leave that for you to have a little bit of a think about. What I would say is that for all of our discussion today, the best source for any information about human rights or discrimination would be the Queensland Human Rights Commission. We'll put up a link for them in a bit. Discrimination is a slightly different kettle of fish, though, isn't it, Frank?
It is, and it's really interesting legally. I suppose when I was up in North Queensland, I was talking to someone whose daughter was thinking about doing law in grade 11. So law degrees, study and all that sort of stuff, and diverge for a slight second here. When I studied property law, so my law degree was externally 5 years. Property law was 12 months of that. 6 months of that was Marbo, which had just arrived. The other 6 months was easements, mortgages, leases, and some other sort of specialty property type areas. Not a single bit of it was strata. And here I am, a strata lawyer, which I suppose is literally decades of experience now. But at the same time, you do criminal law, not one of those, family law, don't want to do that, constitutional law. We did 6 months of that. So the way the Australian system works, this is what happened in Federation in 1901, the states referred up to the federal government certain powers, and anything that wasn't in those powers, Section 51 from memory, is left to the states to regulate. And that's why we have different systems of strata law, because there was no, I suppose in 1901, there was no such thing as a strata title, was there? So all the property laws stay with the different states, which is why we have different regimes across all of the states in relation to property, education, health, crime, all those sorts of things. One of the things that is really interesting from a constitutional perspective at a very high level is discrimination, because there are some elements of discrimination effectively where the federal government has the power to legislate in certain respects, such as age, and not others. So we've got this intermix of federal and state at play. So one of the things that certainly you can't do at a body corporate level is discriminate based on age. One of the really interesting things, and I suppose for those of you that are here listening, this is a slip through, aged care villages or retirement villages normally have these age limits. So if you go to the various states, you've got to be over 55 or whatever it might be, and that's going to be enshrined in the legislation. But interestingly enough, it's the federal government that has the ability to regulate age limits in those jurisdictions. So any state legislation to the contrary isn't actually necessarily enforceable. And that's where we get to with these things. So we've got an interplay of different jurisdictional requirements. And I suppose the best place, Chris, is that Queensland Human Rights Commission website, because that, I haven't looked at it for a while. It used to be the Anti-Discrimination Commission of Queensland. They've got some really good stuff there in terms of information about the style of discrimination that they can regulate. So discrimination based on gender, on relationship status, on sexuality, on age, on race, on impairment, religion, political belief, and so on, sort of thing. So they're in there, and it's a really what's the best way to put it? Touchy-feely jurisdiction to go into.
Look, it is. It actually operates in a very similar way to my former office, in that it's got as one arm, it's about information and education, and the other, it's about resolving disputes. It's just that the way in which they resolve disputes is quite different. So a good example of that, I know that former Anti-Discrimination Commission, now the Human Rights Commission, can and did conciliate disputes about pets, for example, where somebody claimed that they had been discriminated against on one of those criteria Frank just outlined, because the committee had refused permission for their companion animal. So that is an example of where discrimination and strata really do interplay, and it might be a little tricky to work your way through some of those, but what you've basically got to try and take information from both sources and pick your way through the best way to resolve the problem. I might at this point talk about instances where discrimination tends to get misused. I used to hear these sorts of things all the time. Frank, I know that you've heard these sorts of things all the time. And it's a bit frustrating because real life, genuine discrimination is an incredibly difficult thing for somebody to have to deal with, has a real impact on somebody's life. So when somebody misuses the term, I actually think it's a little aggravating and not a great outcome. Doesn't advance anyone's case. I wouldn't have thought so. I often heard that when bylaws were being enforced against somebody, that somebody felt as though they were being discriminated against, and particularly because somebody felt, why are the bylaws being enforced against me and not somebody else? While that's absolutely aggravating, and that tells me that there's a committee that isn't properly aware of its functions and responsibilities. Just because you happen to be the one being having bylaws enforced against you doesn't mean that it doesn't apply, doesn't mean that suddenly you don't have to comply with the bylaws. Somebody else's non-compliance does not make you non-compliant, I think is the best way I can put that.
Well, the second, wrongs don't make a right, do they?
That's right. Yeah, no, I knew that. I was thinking of the term, Frank. I was thinking of it, and it didn't come to me. The same way is when a lot of what happens in a body corporate is about seeking permission or seeking approval for something. There are a whole range of areas where you need to seek permission or approval for something. Just because you get refused permission for something or refused approval for something does not mean you've been discriminated against in and of itself. It might simply mean that whatever it is that you were asking for at that time could not be made, could not happen. Now, if it was not being made to happen because of one of those grounds for discrimination, different story, I would think. Another way in which discrimination might get misused, if somebody puts up a motion or wants something considered at a meeting and it doesn't get up, and there's a suggestion I'm being discriminated against because my motion didn't get up. I'm afraid to tell you that in a body corporate, it's a numbers game. If you don't have the numbers, it doesn't get up, and that of itself is not discrimination. Frank, did you want to add anything to that?
No, mate, I completely agree. And I suppose I don't know, we could be sitting here waxing lyrical about political correctness and PC and overuse of words and all that sort of stuff. And the reality is, for me, that I suppose at body corporate decision-making level, we've got committee and we've got general meetings. So at general meeting, in a sense, there's no way for people to explain why they say no. You throw up a motion, you get 15 votes, the no votes against your motion are 16. People have voted no for whatever reason. There's no real explanation for that. That's then a challenge, I suppose. In Chris's office, you've got the ability to do so based on unreasonable decision making, not necessarily discrimination. But it's at those committee level ones where people are left to use that word because there's no other way for them to explain why they didn't get their way.
Yeah.
And I think that part of it for me is committees need to present like employers. And as annoying as this might be, and don't get me wrong, I get it, I suppose a lot of people come into committee membership and it's supported a little bit sometimes by sort of hanger-oners where, well, you're only a volunteer, you're not getting paid, you've got to do your best. There's statutory protection for committee members personally for acts taken in good faith and without negligence. And in theory, there's this lower bar than there is certainly as a director of a company, and certainly as an employer. So there's this perception, but that doesn't mean you can't simply charge around doing, or you can simply charge around doing whatever you want without fear of repercussions. Because I think if committees acted like employers and actually had to, in a sense, explain their decisions, that would take away a lot of the grief. Because if people just get told no, and there's no explanation of the basis for it, then they're left to grasp at the straws and to get angry and to wonder why. And it's natural for people to shadow box out why. Yeah. So it might be that you're a single mum with 2 kids and your kids have been playing up in the pool and you got refused something on your veranda or whatever it might be. Well, that's only because you don't like my kids. And that might not have anything to do with it at all. It might be because we've got consistency of amenity throughout the scheme. We said no to these 5 people previously. And I think a lot of committees let themselves down by not explaining why. And that then actually makes them explain why. Rather than, no, I don't like her. No, I couldn't be bothered thinking about it. It's, well, we've said no, and this is why we've done it. And more importantly, I suppose, if you wanted to go about it a different way, then we'd consider that.
Yep.
Which is what we have to do as employers.
Yep.
You know, we can't just sort of dress people down, you know, and yes, legislation imposes obligations on us around managing staff and performance management and formal warnings and support people and all that sort of stuff, which in a sense can be a pain at times, but by the same token, it actually can be best practice. It stops people just executing things summarily, and if you explain why, that takes away a lot of the risk of finishing up in the Commissioner's office or in the Queensland Human Rights Commission with one of these allegations, because I can tell you probably the couple of times we've had clients go to the Human Rights Commission, and that example I used before about that mother and her 2 children is bang on point with one we had up in North Queensland, where Bylaws, the kids were running amok. One of the committee members, who was an elderly female, went and effectively upbraided that mother and said, hey, you know, pull your socks up, start controlling your children type stuff. And it was how that was handled and how it wasn't followed through that led to that body corporate having a complaint lodged against them in what was then the Anti-Discrimination Commission of Queensland.
Yep.
And it's just not fun. You know, handled a different way, explained a different way, in a non-aggressive, non-confrontational manner, would have had a completely different outcome.
Absolutely. I think that's a really good point, Frank, that the absence of a proper explanation will only lend itself to a feeling as though I have been discriminated against. I think that's a really good takeaway for anybody watching this today. We talked a bit about how discrimination gets misused. Well, how might it actually come into effect in Strata? And I think we've already spoken about one of the main ways, which is differing rights or obligations for owners and occupiers. And as Frank said, that is specifically prohibited under the legislation. And it happens in a lot of different contexts, that one. But the idea that because you are a tenant, somehow your ability to use common property is different because to an owner's. No, so that is one instance of discrimination. Another one that comes...
That distinction remains just enormous in every building. I remember we renovated our house, moved into a new building off the plan, 190 odd units. The building manager put up a Facebook page, a residence page, not a owner's page or a tenant's page. And some of the, I suppose this is one of the reasons I'm on Facebook, but for these, some of the disputes that popped up on there where an owner started saying, you know, someone stole a TV from the gym. You know what I mean? The gym had a morning TV there, someone stole it. Owner pops on, bloody tenants in this place stealing things again. And then, because it was sort of 50-50, there was at least 60 comments to and fro, everyone slagging everyone else off. Just because I'm a tenant doesn't mean I'm a thief. Well, yes, it just went on and on and on and on. But that distinction remains, I don't know whether it's a different class of occupier from a body corporate perspective, but that continues to exist.
It's also different classes of owners as well. Permanent owners versus so-called absent owners. I mean, there's no difference. An owner is an owner is an owner in the same way that an occupier is an occupier. Which leads to another instance of discrimination is where you have a letting agent who treats the letting pool owners differently to other owners in terms of their obligations to owners and to the body corporate. So let's just clarify that an on-site manager's letting arrangements that's quite separate to body corporate stuff. That's a contract that they have. If they've got a contract with the body corporate to do things around the body corporate, then it doesn't matter if the owner is or isn't in their letting pool, the obligation exists nonetheless.
And I suppose the important thing there sometimes is that management rights owner can wear two hats. There's a caretaking component and there's a letting component. So, and in the caretaking component, in theory, a resident manager or a manager really doesn't report to any individual owner. They report to the committee.
Yep.
So it's not really for me as the owner or the occupier of Lot 35 to go up to them and whinge about the upkeep of the gardens and grounds. And then when you go across to the letting side of things, there are codes of conduct under the legislation, I suppose, the schedules to the BCCM Act, if you're interested. And they as a, you'd almost call them motherhood statements, Chris, I think, wouldn't you? Sort of act with honesty, fairness and professionalism. And to a degree, they're more aspirational than enforceable statements.
That's right.
But it's interesting, the real discriminatory element in relation to a letting side of things is normally contained in the letting agreement that the manager might have with the body corporate, in which the manager agrees not to discriminate amongst owners in the letting pool. So, for example, I'm going to load Frank's unit up so it's 100%. Because Chris isn't looking after me, I'm going to make sure he doesn't get any bookings for December and January in a peak holiday period. Yeah. So that's a problem. So but again, and discriminate in that sense, that's the word that's usually used, but it's not discriminate just because Chris is follows a different religion to what I do.
That's right. And another instance of where discrimination might kick in is in relation to notices. So this is about if I am entitled to receive a notice about something in the body corporate, example, notice of meeting, I should be getting all of those. I shouldn't be getting some, but not others. So I shouldn't, for example, mysteriously not be getting notices which have a direct impact upon me. Hear about that happening quite a lot, that sort of thing. Which then leads me, I suppose, to what can you do about it? So if you think that there is an actual instance of something of discrimination or something which is akin to discrimination happening in your body corporate, what to do about it? And interestingly, we've had a question there from Rian, who I know is a frequent listener and watcher, welcome again, who has actually hit upon the first thing that I was going to mention. So in some cases...
Very topical.
Yeah. In some cases, discrimination is actually unreasonable decision-making. There's a difference between the two things. So Ryan's questions, would it be considered discrimination if a Zoom meeting is held and owners do not have access to technology and or are unable to use technology? I can't comment on the discrimination side of things. I don't know if there's a discrimination criteria that would fit that one, but from a body corporate...
Enabled?
Yep, maybe. But from a body corporate perspective, is it reasonable for the body corporate to pass a motion that all meetings be held by Zoom if the body corporate know that there's at least one owner, or if not one, several owners who can't use the technology? There's actually, I think, been perhaps one or two adjudicators' orders on that topic or around that topic. So, it's an interesting one, that one.
I think where we got to when COVID arrived, 6 months ago now, is that while moving towards electronic platforms does make sense in this environment, it shouldn't be at the expense of disenfranchising people who don't want to or can't move to that platform. And I think, Chris, the example I remember you using, because it's very early in our business relationship, was, say someone's got a really important motion on the agenda and for whatever reason, NBN gets a shovel through it and they can't come to the meeting. There's got to be a way for them still to be able to participate. So what is that? So just locking people out and saying this is the only way we're doing it is not, I think, reasonable decision making as opposed to discrimination.
Right. The flip side of that one, though, is, and one that's often mentioned, is that, well, there are a lot of people of a certain age in the building and they can't use technology very well. I know that there's been a recent adjudicator's order in which that was actually put up as an argument, and the adjudicator said, there's no evidence put in front of me that just because you're old, you can't use technology. So you've got to be careful the arguments that you proffer in that situation. But I think, to answer your question, Rian, I'm not sure about discrimination, but it may well be unreasonable body corporate decision making. What else do you do? Well, I think it just reinforces education and information about process is vital, and whether you require information from the Queensland Human Rights Commission, and put up that link now, or if you require information from my former office, you need to know what you need to know. You need to actually start from an informed basis, and that link is now up there to have a look at. The next best practice tip, ensure that things such as bylaws don't contain any discriminatory provisions. So if you've got bylaws which have different requirements for owners and tenants, that's a big problem. You need to get that looked at straight away, preferably by an expert body corporate law firm who's got a lot of experience doing that.
It's amazing. Bylaws just get registered. No one checks the validity of them, and these things become registered documents that people then try to enforce and assume that because it's registered, it must be right. It's just not.
And then finally, a point that I would make is that at the most basic level, you've got to remember the name of the legislation: Body Corporate and Community Management Act. Keyword there being community. You are living in a community, and so when you're in a community and when you are participating in a community, I think there's an obligation on people to consider different perspectives. So forget about common decency, because God knows there's very little way in which anybody can regulate common decency or courtesy. But from a body corporate perspective, you've got to consider the interests of all owners. All owners' interests have to be considered. Everybody needs an opportunity to provide input or to exercise their right to vote. So it's about putting yourself in somebody else's shoes. If you're on the committee and somebody comes to you and they are aggrieved or concerned about something, ask yourself why. Why are they aggrieved or concerned? Where is this stemming from? Chances are that goes halfway towards resolving the problem. Further question, Rian, back to the scheduling of meetings. Does that apply to the times the meeting is scheduled? There's no provision in the legislation about when a meeting should be scheduled. So it's not as though that the Act says it must be held during or outside of business hours or even on weekends. Can technically be held at any time. What I would say, though, is if the body corporate goes ahead and schedules a meeting in a building where they know that everyone in that building will be at work for whatever reason, the nature of the building, the nature of the people in the building, there might well be an argument to suggest that's not a terribly sensible or reasonable approach. Frank, what would you think?
Agree. And I suppose that's one of those ones is you know, trying to please all of the people all of the time is impossible. So where I'd get to on that one is it's really the committee's in charge of that. The committee should take into account the nature of the owners and the occupiers. So if you want to schedule it during the day or after hours, whatever it might be, the key thing is that people have the ability to participate in the decisions being made at that meeting. So, and that's what, 3 weeks notice, we're going to move towards electronic voting soon. So if you can't get there in person, then you absolutely still have the right to vote and lobby and do all those sort of things. So if you can't physically get there, I think, Chris, we've got on our list running a good general meeting, and we'll be talking at that one about general discussion.
Absolutely.
Moving emotions, changing emotions, you know, because in theory, every AGM run properly would be over in 5 minutes almost.
It certainly would. We've come to the end. Gosh, that flew by, didn't it?
Yeah.
We've come to the end today. One quick question there, or statement. Our strata has stated has to be between 9 to 5 and everyone is working. I assume that you're talking there about a meeting. Again, there's no legislative requirement about times a meeting should or should not be held. But if you have a particular problem with the timing or the scheduling of a meeting, well, think about if you can supply your votes by post or electronically. But if you've still got issues at that point, then the first thing you need to do is tell your committee about that. I cannot attend for these reasons. Is there any chance of changing it? Remember, you're just one person there too. It's got to be something that affects quite a few people.
And probably what I'd add, mate, is sometimes strata managers charge extras for outside hours meetings. Absolutely. Because they have to pay their staff extras. So there's an additional cost to bodies corporate for that. So some bodies corporates like to have them during business hours, which takes away that cost.
Yep.
It's all part of the negotiation at the time.
That's right. Remember, like and share us on Facebook so that we can get these conversations happening. If you've got further questions, drop us an email. The information is there on screen, info@heinzlegal.com.au. And finally, we are going to announce a slight change to our webinar series. We're going to be switching to Thursday webinars as of 15 October. So we will switch from Friday to Thursday, same time, same amazing content, but on Thursdays.
Same back channel.
Yes. Thursdays as opposed to Fridays, starting from the 15th of October. But we'll keep reminding you about that. For now, though, Frank, thank you.
Thanks, mate. Thanks, everyone, for showing up as well.
Thanks for tuning in. We'll see you next week. Talk to you later.
Bye-bye.
Bye.